Well, let's talk about what difference it makes regarding who you employ as your structured settlement consultant. Creative Capital is modeled after my former law firm when I was a trial lawyer. We take a more legal and holistic approach to structured settlements than most of our competitors. But what we do, as I said a moment ago, is unique in that we don't sell annuities. We help you get better settlements. So how do we do that, and what exactly do we do? For one thing, we will appear with you at mediation, and with your permission, of course, and planning in advance, we will participate in the presentation to the mediator and to the defense team. We all know that the defense team measures what they're going to pay your client in a settlement by what their exposure is. Many structured settlement brokers, particularly those who work for the defense, try to put you into a playing field of negotiating based upon the needs of the plaintiff. I've never seen a casualty company pay a claim based upon the needs of the plaintiff, no matter what they tell you. Currently, in mediation, defense brokers and defendants will try to engage the plaintiff team in a discussion about what the plaintiff needs. Now, surely, being able to fill the needs of the plaintiff is an important part, perhaps the most important part of the settlement. But that's not the approach that will get you the most money or get your client the most money. The approach that will get the plaintiff the most money is by demonstrating to the defense team and to the mediator, or if we're in court at a pretrial conference, to the judge, what the defendant's exposure is. And we've seen cases where the defendant had offered up $1 million or $2 million that might go a long way towards meeting the plaintiff's needs, but we have then shown and demonstrated to the defendant and their team that their actual exposure in the case, should it go to trial, is $5 or $8 or $10 million on the same case. So that's the playing field that we want to be on, not negotiating off a number that might meet the plaintiff's needs, and then, of course, factoring in a risk of loss, so we'll give them a discount of 20% or 50%, because after all, the plaintiff might lose the case. But wouldn't we rather be, shouldn't we be, on the playing field that demonstrates that the defendant's exposure is $5 million or $8 million or $10 million, so that when we then factor in the risk of loss to the plaintiff, we're talking half of those much larger numbers.